Good morning, everyone. Anna Gremlin with the Indianapolis MPO here today. Thank you for attending our first ever PROWAG training. We are very excited, obviously, to offer this to you. If you don't know, this is something that has been around for a while, but INDOT is just now, I'm going to say, paying more attention to it and asking for compliance of all LPAs slash MPO funded projects. So offering this training to you as a result. I will tell you following this training, it is being recorded and we will distribute all of the slides. And we're also going to create like a short 5 to 7 question survey about the potential of future trainings. So if you could take that, we'd be interested in offering more trainings either along PROAG or ADA or Title VI or whatever else interests you. So if you could complete that, that would be incredibly helpful. And with that, I'm going to kick it over to today's featured speaker, Jennifer.
Thanks, Anna. Um, and thanks, Anna and Cole, for organizing this and asking to cover this topic. I'm going to go ahead and share my screen. I will let you know that I did forward the PowerPoint to Cole to let him distribute. And of course, as it happens, um, right after I forwarded it to him, I added a couple more slides. So you're welcome to, there's just 2 more slides. You're welcome to email me if you like the updated one. But let me tell you a little bit about, see, now when I do this, my whole screen has changed. So um, the topic for today is the application of the ADA, the Americans with Disabilities Act, Title II, and the Public Rights of Way Accessibility Guidelines. Those are very important to us because there's been a lot of development over the last 18 months or so in terms of rulemaking. So to get started, let me tell you a little bit about myself and my involvement with ADA compliance. So I have my own company. It's called Skolsky Consulting. We primarily focus on compliance with Title II for state and local government and in parks, recreation, and tourism. So we work all over the country, mostly helping state and local or city, county, municipalities. My language isn't working this morning. Sorry about that. To get started already. But mostly our area of focus is parks and recreation. And so the crossover for me here is working in shared use paths. So hopefully this morning I can give you enough information to become dangerous now with the PROAG standards and how those translate to your responsibilities under Title II of the Americans with Disabilities Act. But before Skolsky Consulting, I was at a program at Indiana University for 17 years where we were funded by the National Park Service to provide training, education, and research on inclusion of people with disabilities. And the way that I started out more than 30 years ago with my hometown park district in Rockford, Illinois, as their ADA coordinator, right after the ADA had been passed. Before there was the Google, before you could just look something up on the internet, I literally got the pages of the ADA and the accessibility standards faxed to me as I had questions that came up. And some of you are going to have to Google what a fax machine is. But so I've been around, I've been doing this for a long time. If I can't answer a question for you, I will find the person that can answer the question. So to start with, I want to give you a refresher on Title II and that what that means for most of you, given your designation with a unit of local government. So Title II applies to units of state or local government, and there are 5 administrative requirements depending on the size of the organization. First, that is to designate a responsible employee. That's somebody that's going to oversee the day-to-day compliance with the Americans with Disabilities Act. That's required for entities with 50 or more employees, although certainly as a best practice, we recommend that you have an ADA coordinator no matter the size. Generally, I tell people if they're talking to me, they're probably the ADA coordinator for their organization. But if you aren't sure, I would ask around to see if you have an ADA coordinator, figure out who that is. They would certainly welcome a call from you and to work together with you in terms of ADA compliance. The second administrative requirement is a notice to the public that's required of all public entities, no matter their size. And it's basically includes a non-discrimination statement that your program services and activities are open to people with disabilities. And if people have questions about compliance or feel that they've been discriminated against, who that contact information is and what they would do if they needed to file an informal complaint. That informal complaint also leads into a grievance procedure for entities with 50 or more employees. You are required to have an ADA grievance procedure. It does not have to be separate if you already have a grievance procedure for any type of public inquiry. You could use that same structure for your ADA grievances as well. And then the two that we see the terms most often interchange, but they're very different, is the self-evaluation and the transition plan. The self-evaluation is required of all public entities, and then the transition plan is required of those entities with 50 or more. But with all of these, even though 3 of them are only for larger entities, as a best practice, again, we'd certainly recommend that you adopt that administrative requirement if you're smaller in size. So let's compare the self-evaluation and the transition plan. It's kind of a little bit like comparing cilantro and parsley. They look a lot alike. They might be confused though, but I would tell you if you bit into something that you thought had parsley on it and it ended up having cilantro on it, you would be very surprised, and for some of us, not pleasantly surprised. So, a self evaluation is a review of policies, practices, and procedures. It's looking at, do you have any existing practices that might either intentionally or unintentionally screen out participation by people with disabilities? Identifying those policies, practices, and procedures and making reasonable modification to those to make sure people with disabilities can fully participate and benefit from the program services and activities that you provide. Those, again, were required of all Title II entities, and it was required to be completed way back in 1992. And it was also required to be on file if you were a larger entity for at least a period of 3 years for public inspection. So the self-evaluation is kind of the softer side about how you do things, while the transition plan is really more about the environmental way that you serve people with disabilities. So the transition plan is identifying any type of structural and communication barriers to your program services and activities and developing a schedule for barrier removal. Title II entities were required to have that plan completed by 1992, July 26, 1992. And all of your barriers were required to be completed or removed by January 26, 1995. And I could ask you for a show of hands, how many people completed their transition plans? See if anybody's listening to me now. If you put your hands up, one person did. All right, thank you. 4. That's okay. I won't put you on the spot and list out who that is. But so our challenge with the transition plan is that one, if you think about, when I started doing this 30 years ago, the average time in a position was generally 7 years. Now, post-pandemic, people are in a position generally less than 18 months is the average time in a position. So you can see all of the attrition and the number of people that have come in and out of ADA compliance responsibilities, that a lot of things could have changed. Data might be not be upkept like it should have been. And so between the self-evaluation and the transition plan, many of those can fall behind and fall out of date. Our challenge in Parks and Recreation and public rights of way is we haven't even had accessibility standards for recreation until 2010. So it took a significant amount of time to even know what an accessible playground or swimming pool looked like, let alone the public rights of way that has been under development for the last 15 plus years. And it's only just now that we have enforceable standards according to the Department of Transportation. So there are some reasons to revisit those, and we'll talk about that more in a second. But to kind of again give you enough information to be dangerous, um, in terms of making the modification to policies, practices, and procedures, there would be three defenses under the ADA that you would not modify a policy, practice, or a procedure. And that is because either the modification creates a direct threat to the health or safety of others, the modification is a fundamental alteration to the nature of the service, program, or activity, or the modification creates an undue financial and administrative burden. And so recognize that, this is what the courts would look at in terms of why you would say no. So under our self-evaluation, we look at some of our common program services and activities. And generally, we have this tendency to think that program services and activities have to be structured and staffed. That's not the case at all. Program access under the ADA is a much more broad definition. It's anything that you really deliver to the public. So it could be your laws or ordinances, it might be public meetings, public safety, transportation, health services, the way that you communicate with the public, social services, your streets and sidewalks are considered a program or service, business licenses, permits, your libraries, elections, finance, parks and recreation, of course, festivals, and then even employment. And so because you're a unit of state or local government, we have a much more stringent requirement under Title II than private businesses that are covered under the ADA in Title III. This program's access standard basically states that no individual with a disability shall, because the public entity's facilities are inaccessible to or unusable by individuals with disabilities, be excluded from participation or denied the benefits of the service, program, or activity. So this program access concept is foundational to the delivery of programs, goods, and services under Title II. So it basically means that just because your facilities are inaccessible, your program, services, and activities still need to be accessible. So in terms of our existing facilities, there's no such thing as a grandfather clause under the ADA. We just treat buildings or environments differently based on whether or not they were built before the ADA or if they're new construction or alterations. But under this program access standard, it states that a public entity shall operate each program, service, or activity so that when viewed in its entirety, it's readily accessible to and usable by individuals with disabilities. A public entity should also give priority to those methods that provide the most integrated setting appropriate to the needs of people with disabilities. And so in terms of our sidewalks and curb cuts, the Department of Justice has long held that the provision of sidewalks and curb cuts are considered a program of a city or a county. And I'm going to give you some examples here. Probably one of the most well-known that received the biggest national attention was way back in the early 2000s. There was a case out of Sandusky, Ohio, a young woman named Kelly Dillery who used a motorized wheelchair. She wasn't able to use public transportation, or where she needed to go, there was no public transportation available to her. So she would use the city or county sidewalks. However, those city or county sidewalks did not have curb cuts. So where there were no curb cuts, she would have to travel in the public right of way of the street. She was a young mother that had a toddler that was often known to ride on her lap on her motorized wheelchair. Um, the local police department, seeing her riding out in the side of the street there, ended up giving her a ticket or several tickets, and even arresting her for child endangerment. That case, the Department of Justice intervened and basically hit back at the city of Sandusky and the county there to say that you have a responsibility to, in your ADA transition plan, to develop a schedule to remove any curb barriers where there are not curb cuts to provide a continuous path of travel for individuals with disabilities that are using your city sidewalks. There's another one, another back in 2000, early 2000s, 2005, and I was looking locally for Indiana. That's the city of Gary, where there was an ADA related complaint that went to the Department of Justice under their Project Civic Access, where the city of Gary had to develop a transition plan specific to their sidewalks and curb cuts. And the city or the Department of Justice basically gave them that schedule between 72 and 84 months to correct existing curb cuts and install new curb cuts where they don't exist at intersections. A little bit more recently, there was another complaint against the city of Milwaukee, with a lot of new city development for city spaces, a river walk, and different urban park type areas that were not accessible. The Department of Justice investigated that. They put the city under a court-appointed monitor and a court-appointed independent licensed architect, that the city had to pay for that licensed architect to review the plans for every single project that was to be implemented. And then that independent licensed architect had to inspect each one as construction was completed to make sure that it was compliant. Within the first 2 years of that settlement agreement, the independent licensed architect went back and looked at their sidewalks and curb cuts that were newly installed. And more than 90% of those newly installed sidewalks and curb cuts were non-compliant with the ADA standards. So here's a great example of the need to inspect projects to make sure that it's meeting the minimum standards on new construction, and that you're not paying for anything until it's been inspected and you're assured that it meets the standards. And then here I'm in Fishers and Hamilton County. We've had situations probably in the last 10 years or so where, with new subdivision development, where an individual resident has filed a complaint with the Department of Justice, or actually in this regard, it was the Department of Transportation, because the newly installed sidewalks and curb cuts that were installed by the developer were not actually compliant with the ADA standards. And in that regard, the Department of Transportation and the city were able to put pressure on the developer, because the developer was still building houses in that subdivision, but put that pressure on the developer to go back and fix those sidewalks and curb cuts to bring them into compliance. that again shows the criticality of the inspection point. If that complaint had not been submitted to the Department of Transportation and investigated, it could be that the developer complete the subdivision and walk away, and then the city is on the line for correcting all of those sidewalks and curb cuts because they're considered a program of the city or the county or whoever has jurisdiction for that public right of way. And then there have been times that the Department of the Department of Transportation has been known for withholding federal funds in new construction or alterations until those projects are brought into compliance with the ADA standards. So our program access and how that applies to the transition plan, when viewed in its entirety, can people with disabilities participate and gain the benefits of the program? So we look at our existing facilities, we apply the program access standard, we identify any barriers that need to be removed, and that's how we develop our ADA transition plan. So that ADA transition plan, it needs to include the structural changes necessary to achieve program access. It should identify the physical and communication barriers. It should identify what the solution or corrective action for barrier removal is. It should also have a prioritization and a targeted timeline for barrier removal. And then it should be, those corrective actions should be assigned to responsibility units. So is it a specific city department that is going to be responsible for it? Is it another entity or a different department? Because I work kind of in the overlap between Parks and Recreation and Public Works, that assigned responsibility is really important to figure out who's going to be the lead on which project and what funding source is that corrective action coming from. And then that transition plan actually needs to be kept on file for public inspection until the transition plan is actually completed. So I have a sample here for you of this is of one of our assessment reports. We go out, we look at all of the parks or facilities or city hall or the public library. We develop a report that has what the barrier is and what the corrective action would be. It includes a digital image. It includes a reference to the specific citation and the accessibility standards. We give it a priority, and then we give it a very broad-based cost estimate so that we can better plan for those corrective actions over a series of funding cycles. And then every entity has their own version of a transition planning report. This is just an example that we put together for the city of Mobile, Alabama, that just kind of gives them a close overview of what we need to do at Aaron Park in terms of the park overall, the ball fields, the playground, the picnic areas, and then what we would do for the restrooms and so forth, so they can start scheduling out those projects. And then this is an example for mapping sidewalks and curb cuts to give that transition plan a visual representation. And this was with the city of West Lafayette, where we were able to partner with Butler, Fairman, and Seifert, and they did a spectacular job through their GIS team. And ideally, if you haven't done this yet, this is what I would highly recommend. And BFS could give you a really lot of great resources and tools to be able to do that. But so basically, the city of West Lafayette, they wanted that visual representation to show where all of their sidewalks and curb cuts were in compliance and then those that were not in compliance. And so us developed the field data collection form, tying that to their GIS, where that identified which were city streets, which were county streets, so they knew whose were jurisdiction were which. And then they used a team of interns and students from Purdue where they taught those students how to measure the sidewalks and curb cuts. And then they would get a rating. So that kind of fits into the prioritization. That sidewalk rating can help us determine better which ones need corrective actions and kind of float those to the top. So if you haven't done this yet, this is something that I would highly recommend. You could do that manually. There is also a couple different programs now that use visual AI to do the mapping so that you wouldn't actually have to bend over with a smart level or a tape measure to measure the running slope or the cross slope. So some other reasons why it might be necessary to revisit your self-evaluation and transition plan. Maybe it was never completed or only partially completed in the 1990s. I will tell you, if you get an ADA complaint during the investigation process with either the Department of Justice or the Department of Transportation, the very, very, very first question they're going to ask you is, where is your self-evaluation? Where is your transition plan? So those documents serve as their first line of defense, those CYA documents, to show that you know that the barriers exist and this is your timeline for removal. Maybe you've had inquiries from the disability community about, when are you going to make a corrective action on Allisonville Road? Maybe some facilities have changed substantially from what the data that was originally collected in the 1990s, and that data hasn't been updated. And so that it would be another reason to revisit those. Your agency policies might have evolved. We had a situation with a very large city that in the early 1990s that they had modified a policy to make it compliant with the ADA. And then with all that staff turnover, the policy got changed back to its original, and it was no longer inclusive or welcoming of people with disabilities. And so that was one thing that we uncovered through the self-evaluation process, that this got changed back and people didn't realize that had been changed for the purpose of inclusion of people with disabilities. You might have new leadership staff or new access team members have come on board. Again, the accessibility standards have been revised. We didn't currently know what an accessible public right-of-way looked like. Do we have to have audible and visible alarms? And then again, it's a demonstration of your good faith effort towards ADA compliance if you get an ADA complaint or litigation. So with large entities, doing a self-evaluation and transition plan for the entirety of the entity, that's a pretty big piece of cake. So what I like to do instead is break that down. This is an example of how we've done that with larger cities, that we look at separate transition plans, one for those facilities that are owned by the municipality, another for those that are leased by the municipality. That way, if those spaces are leased, when the lease comes time for renewal, we know what the barriers are, and it becomes a point of negotiation with the landlord. Another subdivision there of looking at parks and recreation completely separate from your built structures like City Hall or like the local library. And then having a completely separate plan for your sidewalks and curb cuts. And then if you have any other special authorities, like if that's if the convention center or there's a stadium that is part of your special authority, having its own plan for that type of facility as well. So as Anna had alluded to, our public rights of way rulemaking has evolved, and we have new guidance. We're farther along than we've ever been before, as of December of this last year, 2024. So the rulemaking for public rights of way, if you think of the ADA was passed in 1990, Our first set of official accessibility standards came out between 1991 and 1992, and then they didn't get updated until 2010. And even with that update, it did not address sidewalks and curb cuts as thoroughly as it needed to. So that U.S. Access Board, who is the federal designated agency that writes the accessibility standards under the ADA, they convened an initial group of stakeholders from across the country and started meeting around 2011. And then that group issued a preliminary guidance of what they thought the accessibility standards should look like. The Access Board then, I'm sorry to say, they kind of sat on that for 12 years there. But the Access Board finally in 2023 was able to issue the public rights of way for a final rule. However, in order for that final rule to be enforceable, it has to be adopted by the enforcement agencies. So federally, for federally conducted and federally assisted projects, that was adopted by General Services Administration in 2024 with that effective date of last September under the Architectural Barriers Act. And then, as I mentioned, the Department of Transportation adopted the Public Rights of Way accessibility guidelines in December of 2024, making the effective date this last January 2025 as part of the ADA standards that are applicable to public transportation facilities. That still does not necessarily get us down to the public sidewalk or intersection that might be in front of City Hall or the public library if it's not part of a public transportation facility like a bus stop. We still need that rule to be adopted by the Department of Justice for it to be enforceable under the ADA. However, as a best practice, we would recommend that even for those types of facilities that we're using these accessibility guidelines now, as they define both in scope and the technical provisions, what is it that makes that sidewalk or curb cut or public right of way accessible. So under our scope, and I've included here the Access Board link to the entirety of the final rule. The scope basically states that anything newly constructed in terms of pedestrian facilities or altered existing facilities, there needs to be a pub that has a public circulation route and use on the public right of way has to comply with the guidelines. So anything that you build new and anything that you alter has to be brought into compliance with the accessibility guidelines. Anything that you provide temporary or permanent, those are considered pedestrian facilities. Those are also covered under the public right of way. So if you have a city block where construction fencing is going up and they're doing construction around the entirety of the building and the sidewalk is closed, because you provided that sidewalk, you need to provide that temporary sidewalk, and that temporary sidewalk has to be accessible. Then alterations to pedestrian facilities, and then the pedestrian access route must connect to accessible elements, spaces, and pedestrian facilities. So some of the other scoped elements include the alternate pedestrian access routes, transit stops, passenger loading zones, detectable warnings. Detectable warnings are here to stay now. Pedestrian signal heads or pedestrian activated warning devices, protruding objects, vertical clearance, pedestrian signs, street furniture, transit stops and transit shelters, on-street parking spaces, passenger loading zones, stairs and escalators, and handrails. So first, let's define our alteration or what's being altered. So under the rule, an alteration is a change or an addition to a pedestrian facility in an existing developed public right-of-way that affects or could affect pedestrian access, circulation, or usability. So if the sidewalk, if it's not a developed area, meaning that it's not construction, it's basically an open farm field that has been turned over to the municipality for development, that is undeveloped. But if you put a road through it, now it's become developed. So developed is anything that contains a building, pedestrian facilities, roadways, utilities, or other elements. So we have this concept now, we have an overarching concept of the pedestrian circulation path. So this pedestrian circulation path, it's an umbrella term. It basically means where any pedestrians are intended to use a facility. And so that scoping requirement where pedestrian facilities are altered, they shall be connected to a pedestrian access route. The pedestrian access route is a subcomponent within the pedestrian circulation path. And then in addition to that, a transitional segment must be used to connect to that pedestrian access route in those areas that have been altered. There's also a specific clause that has been added that you cannot reduce access. An alteration or a pedestrian facility or element shall not decrease the accessibility of an existing pedestrian facility or element or an accessible connection to an adjacent building or site below the requirements of the guidelines. There is a clause that allows you to deviate from the guidelines, but only in the event that it's providing equivalent facilitation. Again, it cannot reduce access. So this equivalent facilitation is the use of alternative designs, products, or technologies that result in substantially equivalent or greater access and usability than the requirements of the guidelines. And that if you are that's for ADA covered facilities. If you're working on projects that are federally funded or federally conducted, those are covered under the Architectural Barriers Act. And if you wanted to do that type of equivalent facilitation, it actually means getting a waiver from the enforcement entity to allow for such deviation from the standards. And that is only done on a case-by-case basis. So there is a clause. So when the public rights of way came out, because I primarily in Parks and Recreation work with shared use paths or bicycle paths or greenways. I had a lot of questions and went right to the access board with like 10 different scenarios and said, well, what do I do with this type of shared use path? Or what do I do with this type of shared use path? And I kind of jokingly say that this is your get out of jail free card, is this clause on existing physical constraints. So this is not an area that is an open farmland that you're about to develop. This is an existing physical space where those existing physical constraints make compliance with the applicable requirements technically infeasible. You are still required to comply with the requirements to the maximum extent feasible. And I'll give you a couple examples of those, but existing facility physical constraints include, but are not limited to the underlying terrain, underground structures, adjacent developed facilities, maybe you're landlocked, drainage, or the presence of significant natural or historic resources. So remember, we have that umbrella term called the pedestrian circulation path. Basically, it's a sidewalk or a walkway, a bike path, a shared use path. Within that, we need to have this new term called a pedestrian access route. The pedestrian access route is a continuous and unobstructed path of travel provided for pedestrians with disabilities within or coinciding with the pedestrian circulation path. And back to the official definition of that pedestrian circulation path is it's a prepared exterior or interior surface provided for pedestrian travel in the public right of way. So our technical requirements for the pedestrian access route, the clear width, how wide does it need to be? At a minimum on our standard city sidewalk, it needs to be at least 48 inches wide. You might have a city sidewalk that is 60 or 80 inches wide. The pedestrian access route is a clear 48-inch minimum width within that larger circulation path. Within medians and pedestrian refuge islands, it has to be at least 60 inches wide for the pedestrian access route. And then where shared use paths cross the medians or pedestrian refuge aisle, again, that has to be at least 60 inches wide, or at least the width of the crosswalk, whichever is greater. And then on the shared use path, this is where it's substantially different than the city sidewalk. On the shared use path, the pedestrian access route has to be the full width of the shared use path. So other technical provisions are maximum grade within the highway right-of-way. That means that the pedestrian circulation path is immediately adjacent to the roadway. That maximum pedestrian access route, the maximum grade is 1 in 20, or roughly what is 5%. There is an exception, however, that allows you to use the grade for the established street. If it exceeds 5%, the pedestrian access route can match the grade established for the adjacent street. It cannot exceed the grade of the street. So if your street is at 7%, your maximum grade for the pedestrian access route is at 7% as well. It could not be at 9 or 12%. There's also an exception for the pedestrian access route in the crosswalk, where the roadway is designed for a super elevation that is greater than 5%. It allows for that in the crosswalk. And then there is a note for ramps. Ramps does not allow curb ramps or pedestrian access road following the grade established for the street consistent with the requirements of this section. So the pedestrian access route, our maximum slope. So we have our 5% maximum running slope, our maximum cross slope, where we're not part of the crosswalk, is 1 in 48, or roughly 2.1%. If we are part of the crosswalk, it's actually dependent on where the crosswalk is located. So if we're at a yield or stop control, we're at 2.1. If it's an uncontrolled approach where there's not a stop or yield, you could go up to that 5% for the cross slope. If there's a traffic control or a pedestrian hybrid beacon, that again would allow for the 5%. And then if it's something that is mid-block or at I hate to say it, at a roundabout crosswalk, it's no steeper, it's no greater than the street grade. So I want to give you a note about what we just talked about there between the running slope and the cross slope. That is the maximum. So once you hit 5.1% or 6% or 7%, you're out of compliance with the maximum allowable slope. So when we're designing for new construction or alterations, it's really important that we design for the construction tolerance, because all the projects that you've worked on, things happen on site that you end up deviating from the construction drawings. And so in that regard, the Access Board did a study and issued a report back in 2011 about construction tolerances. And I actually have this set up in a table that is a little bit better to use. So if you were designing new or making an alteration, the recommendation from the Access Board is that far right-hand column, that blue column that says dimensional tolerances study by the Ballast architectural firm. So for years, I've worked with the National Park Service and the Denver Service Center. They had established what their maximum design standards would be to allow for construction tolerance. And you can see that the ballast recommendations are a little bit more stringent than even the Park Service designs to. So if your accessible route, your maximum slope is 5%, the ballast study recommends that you're designing at 4%. If your maximum slope for a ramp is 8.33%, the ballast report is recommending that you're designing for 7.1, or I'm sorry, 7.5. If you're looking at the cross slope or at the accessible parking spaces where the maximum slope is 2.08 in all directions, the ballast report is recommending that you're designing to 1.5. Okay, so back to our pedestrian access route. That clear width, where the clear width is less than 60 inches, there's a requirement for passing spaces. This is the same as the accessibility standards for the indoor environment, where that route is less than 60, you have to provide passing space at intervals that are no greater than 200 feet. And that passing space has to be at least 60 inches wide by 60 inches deep. Changes in level, the changes in level requirement is the same as it is for the indoor environment. Grade breaks have to be flush. You can have changes in level that are vertical up to 1/2 of an inch, but anything between 1/4 of an inch and 1/2 of an inch needs to be beveled. And so I will tell you, in the outdoor environment, this is the #1 deficiency that we end up writing up that becomes part of the transition plans, is most frequently where we have changes in level where two different types of surfaces meet with each other and the change in level either hasn't been beveled or it's greater than 1/2 of an inch. Horizontal openings, this is pretty close to the same as the built environment under the ADA standards. It basically says the openings in the ground surface cannot exceed the passage of a spear more than 1/2 of an inch. It does allow for those openings to be elongated. However, they should be installed so they're perpendicular to the dominant direction of travel. And then this is very helpful, especially for those of you that are working on the shared use paths where you might have some type of railroad crossing that you're not able to, either it's still an existing railroad or you're not able to remove the tracks. There's more guidance here now about what that surface opening can be. And so that's dependent on what type of regulation there are for the at-grade rail crossing. So if it's regulated by the Federal Railroad Administration, the flangeway gap is allowed to be 3 inches wide maximum. And I want to make sure if, let's see, and then the cross tracks, okay. And then if it's not regulated by those safety regulations of the Federal Railroad Administration, then the maximum gap is 2.5 inches. To our alternative pedestrian routes, if you, again, have to provide a temporary sidewalk, you need to have signage. This is where one of the few places where the accessibility standards specifically say that you have to have signage, and that has to identify what the alternative pedestrian route is at the decision points that actually give people enough time to react, or maybe they're going to actually change their mind about which side of the street they end up using, or maybe using something even different from that temporary or alternative pedestrian route. The surface of that route cannot be less accessible than that path that was temporarily closed. And there's that minimum continuous clear width of that 48 inches. So there's more guidance on both perpendicular and parallel curb ramps, on what the maximum allowable slope, that typically that 1 in 12 or that 8.3%, that has not changed at all. The most significant difference here is that I wanted to make sure you're aware of is that for shared use path, the clear area has to be as wide as the shared use path. So the curb ramp itself is the entire width of the shared use path, and the clear area also has to be the entire width of the shared use path. The same type of thing with blended transitions. If we have a curb ramp that can go over 5% and up to 8.33%, a blended transition is one. It's like a curb ramp, but it does not exceed a slope of 5%. And this is where I would recommend, if you can use a blended transition, to use that instead. The very first version of the ADA accessibility standards under ramps, that actually used to say that you should use the least possible slope. So whereas wherever you can use the least possible slope, that would be what we would recommend. So the running slope there, the maximum is 5%. And then other common requirements for the curb ramps and blended transitions that are not part of the shared use path, that is the clear width of the ramp or the blended transition still needs to be at least 48 inches when it's not part of the shared use path, but when it is part of the shared use path, it has to be the total width of that shared use path. And then considerations at gutters and streets where there's a change of grade occurs, the change of the grade shall not exceed 13%, or a transitional space shall be provided at the bottom of the running slope or of the curb ramp or the blended transition. And then perpendicular curb ramps, parallel curb ramps, landings, and the 48-inch minimum width for blended transitions. All of those, except for those that shared use paths, shall be wholly contained within the width of the crosswalk that they serve. And then again, that goes back to the shared use path, that full width shall be also wholly contained within the crosswalk. And then changes in level, specifically at curb ramps, blended transitions, and in the crosswalks, are not permitted. One of the few technical provisions that address the needs of people with visual impairments is in regards to protruding objects and vertical overhead clearance. We need to maintain a vertical overhead clearance of at least 80 inches above the ground surface. And then anything along the greater pedestrian circulation path, not just the pedestrian access route, but the greater circulation path, cannot protrude more than 4 inches into the circulation path. If it does protrude more than 4 inches, then it needs to be cane detectable with the leading bottom edge no greater than 27 inches. So there's other technical provisions, and for the purpose of our time and to be able to take any questions if you have those, I'm not going to go into all of these other areas, but just highlight a couple of them. But there are other technical provisions. So detectable warnings, crosswalks and crosswalks at roundabouts, accessible, and I just like roundabouts is bold here. And I think that it's kind of a joke in Indiana now because we're becoming so used to it. but in my hometown in Rockford, Illinois, they have their first roundabout there, and it took months for people to figure out how to use those. But anyway, so roundabouts, um, accessible pedestrian signals, transit stops and shelters, and passenger loading zones. Some areas that I want to make sure and highlight with you all, based on the kind of overlap of shared use path and sidewalks and funding for those types of projects. First, on-street parking. So it might be very common for you to have a project that is beneficial to a facility of your municipality that does not necessarily have a parking lot. And the only way that people can drive to it is and park there is that there's available on-street parking. So an example here, neighborhood parks are, most known for being smaller in size, but they don't typically have parking lots. So we have much more specific technical provisions for what an accessible on-street parking space looks like. If you're familiar with the notice of proposed rule, that space used to be determinate about um, uh, what your encroachment was, or how much you had in terms of space to in the easement, so to speak. That has been taken out, and that so it used to kind of there used to be a trip about whether or not you had 14 feet of clear width, uh, indicated whether or not you had to have an access aisle adjacent to the accessible parking space. That's been removed, and so basically, for an on-street parking space to be considered accessible, it has to be at least 13 feet wide. There are some exceptions for the alterations based on those physical constraints. Um, it needs to be 13 feet wide. It has to be at least 24 feet long. It's parallel shall not encroach on the traveled way. And so we have to think about that extra space is critical for a person to be able to open their car door, set up their assistive device, their wheelchair, their scooter, their walker, and transfer out to use that device without the hazard of vehicular traffic. So, and then that parking space needs to be connected to the pedestrian access route where curb ramps and blended transitions are used. They shall not reduce the required width or length of the parking space. And then where two or more parallel on-street parking spaces comply with those dimensions or are continuous on a block face, each accessible parallel on-street parking space shall have its own independent connection to the pedestrian access route. You could do one right after another, but you shouldn't have to go into another parking space in order to use that independent connection to the pedestrian access route. And then they're identified with signs with the international symbol for accessibility. So when I talk about reaching out to your ADA coordinator, this is an area that they would greatly welcome your input to, because I will guarantee you they have a list of sites that are owned by the municipality that don't have parking lots, but they offer or on-street parking is available, and they don't yet have an accessible parking space, that they would welcome your input and the opportunity to provide that accessible parking space. So for the purposes of our conversation about shared use paths and some of the other amenities, I want to make sure that we're defined on these different types of paths and how they're defined by the federal accessibility guidelines or standards. And so in the ADA accessibility standards, we have an accessible route that could be indoors or that could be outdoors. We have to have at least one that connects the accessible buildings, facilities, elements, and spaces on that site. So on a college campus, you could have an exterior accessible route that connects those buildings, but you have to have at least one that connects the site arrival point, the main entrance, and to all of those different accessible elements and spaces. In the outdoors, we have some additional definitions under different guidelines or standards. And the reason that I'm sharing these with you is that they have different technical provisions and in some cases allow you to have a steeper slope. So I'm going to back this up with also, just because we call something a trail, like the Monon Trail or the Big Three or the Big Four Trail or the Nickel Plate Trail, just because we call what I've listed, those are all shared use paths. But just because we call it a trail doesn't mean that it meets the trail definition under the federal accessibility standards. And so that's why it's important to understand what the type of path is before you can actually apply the technical provisions. So for federally conducted and federally managed lands, we have an outdoor recreation access route under the Architectural Barriers Act that connects to picnic and camping facilities within a site. Under the Architectural Barriers Act, we also have a trail definition, which for the purpose of this discussion, that trail is a pedestrian route developed primarily for outdoor recreational purposes. It's a pedestrian route developed primarily to connect elements, spaces, or facilities a pedestrian route that is developed primarily to connect elements or facilities within a site is not a trail. So a trail under the accessibility standards is for the specific purpose of recreation and it's pedestrian only. It does not include equestrian use or bicycle use or motocross use or ATV use. It is only for pedestrians under the definition for the accessibility standards. And then a shared use path, those that the Monon, the Big Three, the Big Four, the Nickel Plate, those are actually the shared use paths. And so under the federal accessibility standards, we're calling them shared use paths instead of bicycle paths because they can also be used by pedestrians. It might be, it could be supplemental to an on-road bike lane or shared roadways, but its design is similar to a roadway design, but on a smaller scale and for lower speeds. So the big differences here for your shared use paths, the requirements, there's not actually a section on shared use paths, unfortunately, under the PROWAG guidelines. Instead, the reference to shared use paths is salt and peppered throughout the technical provisions. I did a search yesterday. I think it appears like 15 times. So you actually end up having to go to the specific technical provision to see how it applies to the shared use path. So in 302, the shared use paths, the clear width again has to extend for the pedestrian access route, has to extend the full width of the pedestrian circulation path of the shared use path. And so that's that whole width, whether or not you're on the Monon, the Nickel Plate, or any of those others. Then it also includes the clear area and landings at the curb ramps or blended transitions. That encompasses the whole entirety as well. Crosswalks, that has to be the full width. And our maximum running slope for our shared use path is basically 5%, or the exception allows to match the grade of the established street when it's within the highway right of way. So if you think of something like the Monon Center or the Monon Trail that leaves the highway right of way and is going through large developed areas that are not part of the right of way, we're stuck at 5% now if you were building that new. It's only in the regards of that existing physical constraints. Yeah, I have that flashing there for you to know that um, you might be able to go to a steeper slope. So 5% for you all is going to be key because what happens with an accessible route when we exceed 5%? In the built environment, if we're outside of the highway right of way or the public right of way, it means that we have to have handrails and landings because over 5% and up to 8.33%, that is a ramp. So I have an example here. This is, I think, one of the when I say it's the big three or big four trail that connects to a park. If you're using your shared use path to connect to spaces within a site, sections of that shared use path change from being a pedestrian access route that is part of the public right of way to being actual accessible routes. So if you look up at Whitestown Road, the shared use path is running in it along parallel north with Whitestown Road. If it comes into the park and it starts connecting to, say, it wants to go back past, it wants to connect to the restroom buildings, that segment now is an accessible route. So that, that is where you have to decide, okay, along Whitestown Road, my shared use path is able to use the same grade as the roadway, but now that I've turned into the park, maybe the roadway was 7%, I've turned south into the park and I need to connect to the restroom building. That's actually an accessible route. And that accessible route has to comply either if it's over 5%, we need to have handrails and landings on it. And I, as a park and recreation professional, I don't like to see handrails and landings all over the place. So my goal is to be less than 5%. Bollards. This is another significant change that, and when we used to assess these, that an accessible route in the built environment can go down to 32 inches. And we used to measure around bollards to make sure there was a minimum of 32 inches, but actually the new rule indicates that the bollard has to be clear for at least 48 inches measured to the edge of the obstruction. So in uh, the top example there where that bollard is, there is not 48 inches on either side. And some people would argue if you have to have at least a 48-inch opening, what's the point of the bollard anyway? Maybe it has, if you're trying to keep vehicles off of or prevent them from going down the shared use path, maybe it needs to be a different point of entry altogether. In the lower photo there, the bollard is actually a planter, and I didn't have my tape measure out that day. It may or may not be 48 inches on the left. It's definitely not on the right. So that's something that if you have those types of projects that have been completed, I would definitely go back and take a look-see at those. And then other street furniture that would be covered under the public rights of way accessibility guidelines. Drinking fountains. There's a misperception that the only type of drinking fountain that if you provide it, the only one that you have to have is the lower wheelchair accessible one. That's not true. You actually have to have two. One is the lower wheelchair accessible unit. The second is a higher standing unit for people that have difficulty bending or stooping. Where you have public street toilets that are permanent, They have to be compliant with the toilet compartments requirements and the ADA standards. Where you have portable toilets, if you only have one, it has to be accessible. If you have clusters, at least 5%, but not less than one of each type at each location has to be accessible. If you have tables, the seating, 5% of the seating has to have space for wheelchair seating, but not less than one. If you have sales or service counters, like you would walk up to, like either maybe an admission or concession counter outdoor adjacent to the route, that would not be greater than that 34 or 36 inches. Benches at transit stops, there needs to be clear space adjacent to the bench for wheelchair seating. And then benches at other locations, 50% are scoped. 50%, but not less than one at each group must have clear space adjacent for the wheelchair seating. And that wheelchair seating should not overlap the shared use path or the public or the pedestrian access route. And then any operable parts need to be within the reach range, operable with one hand or less than 5 pounds of force without twisting, pinching, or grasping of the wrist. So some of the common issues that we see out in the field, those handy dandy little bike repair stations, those are protruding objects. So we need to pull those off of the path that ideally we need to have accessible surface, at least 48 inches, turning space, at least 60 inches. That little piece on the upper left-hand corner that sticks out, I'd like to see that pushed back so that it was running parallel to that adjacent resting area instead. Picnic tables that are in grass, if you're providing that table, it needs to be part of the accessible route. Changes in level on surfaces where two surfaces meet, or where you have a lot of asphalt heaves, mapping those out, putting them into a condition assessment and scheduling those for repair or repavement. And then some of those other amenities on the upper right hand and lower left hand side, dog waste bag receptacles, those have to be within the reach range. Waste signs, they need to be within the viewing distance. And typically, if you look at the AASHTO guidelines, any type of post have to be 24 inches off of the path. If it's 24 inches off of the path, that means we need to have an accessible surfacing that connects to those elements now. So under the sign and adjacent to the post or the trash receptacle or the information kiosk, we need to extend those surfaces. And then our benches, in the center lower section, having that adjacent space adjacent to the bench, and ideally so that the wheelchair space and somebody seated on the bench are seated shoulder to shoulder. That portalet, we need to have an accessible route. Look at it's been installed behind a bollard, so the door is obstructed from use. And then that drinking fountain, and our new thing is having bottle fillers all over the place. Well, this is an Indianapolis manufacturer with an inaccessible unit, so don't buy this one. We reached out to this manufacturer because we were finding so many that were newly installed and non-compliant. And we said, we can show you how to make this accessible. And so they have a brand new unit that has all the bells and whistles on it, the high fountain, the low fountain, the doggy bowl, and the bottle filler, and everything is accessible. The high unit is also cane detectable. So, if you are buying furnishings, make sure that they meet the accessibility standards. I'm going to open it up for questions if people have those. I see that there's one in the chat Cole has also indicated that if you want to raise your hand, he will moderate those. But I do have homework for you. Cole, if you want to, if anybody has a question, we can take a couple minutes and then I'm going to give you your homework.
Yeah, if
I
you have a
see from,
question, you just want to raise your hand and it'll let me allow you to speak. Or you can type it in the Q&A.
thanks, Cole. I see in the Q&A there's a question from Tammy. You know, I was trying to get away from detectable warnings. So, if detectable surfaces are required at commercial or residential driveways? No. Um, there's more guidance on that, and no matter what way I answer this, Tammy, I won't be able to clarify it. Um, I've even been given direction that the detectable warnings are not even required at the parking lots, that they're only actually required where there's vehicular traffic. So that is a great question. Email me again and we will, if you have more specific scenarios that you want to share, we'll get some more interpretation for you on that one. I would also say the access board has an 800 number and they have staff available Monday through Friday that you can either call them or you can even send an email to ta@access-board.org, or I'm sorry, .gov, and they have a fantastic transportation specialist there now, Juliet Schultz. She is fabulous. She's likely to get your PROAG questions. I see a second hand up.
Hey, Christian, you should be able to talk now.
Hey, can you hear me?
Go ahead.
Hi. So thanks for presenting, Jennifer. I think this is really helpful. I had a question about your slide about designing for construction tolerances. I wanted to just make sure that I understand um, the the sort of point of that. So is that to dictate things happen in construction that are unexpected. So let's be more conservative than we need to be
Yes.
during construction. And that way,
Yes.
at the end, we actually get the result we want.
Absolutely, yes. That's
Okay.
gonna that is the sole purpose for that. And so, and let me give you another example, Christian, is so that I recently had a project that we had already identified what was not compliant on the sidewalk and the accessible route through the park and to the restroom building. And so the city went through, they rebuilt several facilities within the park and the sidewalk itself. And they drew their drawings in this regard. They were using the Park Services 4.75.
Mm,
And they knew there were sections of it that were steeper than that. And so to measure for accessibility compliance, you should be using a 2-foot digital level, not a 4-foot, not a 5-foot, not a 6-foot,
mm,
2 feet, because that most closely replicates the footprint for an assistive device like a wheelchair, scooter, cane, crutches, walker. So they went in with their 2-foot level, measured multiple locations on that, and then called the contractor back. And the contractor had measured it with a laser transit from top to bottom. And so
mm,
he got an average instead of all of those segments in between that were non-compliant. And so then they get me on the phone, aside from the contractor, and they said, well, what should we do about this? And I said, well, what's the drawing say? And they said, well, we drew it at 4.75. And they said, and so we said, well, then the contractor needs to fix it because the drawings were right. And you even allowed for that construction tolerance. So there shouldn't be any sections there that are, over 5%. And if we're at 6%, on those particular segments, We moved from being the public right of way for being an actual accessible route into the facility. And so in that regard, we would have had to have landings and handrails because then we went to a ramp. So that, yeah, that we found that that is the best way to protect yourself.
Okay, great. Thank you so much for explaining that.
You're welcome. So any other questions there? Okay, well, um, okay, so let me get to your homework is what I would highly recommend for all of you. And again, this is enough information to be dangerous because I could, talk about accessibility for days and days and days. And but this is to get you thinking and hopefully have a new accessibility lens as you're looking at your projects. So my recommendation for all of you is to review your most current ADA self-evaluations and your transition plans. I will tell you, if you did the requirement for NDOT in terms of a transition plan on sidewalks and curb cuts back in 2012, you only have a partial plan. You only have a partial self-evaluation. It only deals with sidewalks and curb cuts. It does not necessarily deal with all of the program services and activities you as a municipality offer. So go back and look at that. Do you have any policies that have been modified? Do you have new policies that have been enacted since it was last compiled? Look at the transition plan. How old is the data? Have you been keeping current on the data? Are there projects that have been scheduled? Have you reported what those corrective actions are? Like, do you really know where you are in the data? Generally, we're finding now that as a good rule or of thumb or a best practice is to revisit those transition plans on a 7 to 10 year cycle to make sure that the data is accurate and up to date. If you don't have an accessibility management team, I highly recommend that you have representation from each unit or department within your organization because the ADA coordinator cannot be all places at all times. It's very helpful to have, somebody from Parks and Rec, somebody from libraries, somebody from Public Works, somebody from facilities, someone from human resources, somebody from legal. Don't send them the meeting invites, but somebody from legal is eventually going to be involved. But getting all those people together and talking about the self-evaluation and transition plan, where are you at? Does it need to be updated? Again, because that is your first line of defense, your good faith effort that shows that you have been working at making your program services and activities more inclusive for people with disabilities. And then the ADA also requires that you seek input from people with disabilities. That's an ongoing requirement. So if you can, convene advisory committees specific to the needs of people with disabilities, that would be fantastic. Like using in Fishers, we have a mayor's advisory committee on disability that helps to guide the policy for any policies that might be enacted for the city and make sure that it's more inclusive. So an advisory committee, focus groups. I love to use the July anniversary of the Americans with Disabilities Act as a time to hold public listening sessions and invite the public to give you feedback on what of your facilities that they've used, where they've had challenges, what they would like to see to make it more accessible or more usable. And then, obviously, those practices of universal design where you can go above and beyond the minimum accessibility standards. Because what we've talked about so far is it's basically the worst that you can do. and some things still be considered accessible. But how can you design above and beyond that? And I think, there's so much more that we've learned over the last 30 years in terms of urban design and outdoor environments that are more inclusive of everybody, and not just a smaller population of people with disabilities. So with that, I've shared my contact info, some resources I would love for you to tap into. Now, some of you might be familiar with the AASHTO bicycle guide. I think the last publication date on that is like 2012 or 2015. We've been waiting for that sucker to get updated for years. And there is an outside firm, very well known tool. They're fabulous on bicycle design. They've been working on that update for years. It's not getting, it's for we thought it was going to be released like 3 or 4 years ago, but it's not getting the approvals, and clearly there's some internal discussion about what they want to see or not see. The recommendation for Tool is that they just actually developed a publication for Ohio DOT called their Multimodal Design Guide, that they've used a lot of the content that was supposed to go in the AASHTO guide. So look to that as a guidance for you. It's not real great on the accessibility part. It could be a lot better, but it's, one step better than the old AASHTO guide that we have. I've included the link to the direct link to the public rights of way accessibility guidelines on the Access Board website. On-demand webinars, the Great Lakes ADA Center and the U.S. Access Board run monthly free webinars. There is a session by Juliet Schultz and Scott Windley that talks about much more of the technical provisions than I've been able to cover in this time, including like the accessible pedestrian signals, and other types of issues, transit stops, and so forth. So check those out. Subscribe to the Great Lakes ADA Center listserv, and then you'll get the announcements as new sessions are scheduled. There is also a National ADA Symposium that is held each spring or summer. Next year, it's going to be in Phoenix, but there's also a virtual version that will be held in May. That's a great opportunity to get more updated information and continuing education on the Americans with Disabilities Act. And then if you are an ADA coordinator, there is actually a certification program through the Great Plains ADA Center that attendance in the symposium can count towards your certification. So some great resources. I live in Fishers. I live right down the street from you. Anytime you have questions, I'm happy to take those, or if you have projects, plan reviews, or if you want to do a facility walkthrough, I will be happy to do that for you as part of the services that we provide. But please feel free to reach out. If you have a question, generally, probably somebody else has had that question as well, and we can connect you to those resources. So with that, I think I had 1 minute left, Cole.
Thank you everyone for coming. We will send out the slides and I'll post this recording on our webpage. I'll send that out to everybody. Thank you all. And thank you, Jennifer. That was great.
Thank you. Have a great day.